Hi YouTube, happy Friday.
Hi.
We're about to join on Facebook Live in just a moment. We'll start our showing. Which we usually start with YouTube. They're strong and faithful. Facebook sometimes glitches on us, so we always have they're always there, so. Happy Friday, Facebook and YouTube. Welcome to Disclosure Live with Brandy Austin Law. I'm Heather, and today I have with me.
I'm Bryant Surly Strong. I'm the personal injury paralegal here at the Brandy Austin Law Firm.
Okay, today, of course, is March 1st, 2019. On today's episode, we're going to discuss a few news stories and then, of course, get into our topic of conversation, which is slip and falls. So, but first, we'll cover a few fun things and a couple local news stories. Scroll, Hunter. Today is National Pig Day. Basically, National Pig Day is observed annually on the 1st of March, which recognizes the domesticated pig. This holiday includes events and celebrations at zoos, schools, nursing homes, sporting events around the United States. Big parties, big parades, and gatherings with pig collectibles are a few of the other events that we have commemorated around National Pig Day. Pigs are clever and intelligent animals. However, most people are not aware of their high level of intelligence.
That's true.
Yeah. They're often used as household pets and basically can be trained and taught tricks. I do have some friends that actually have some pigs, and so they're kind of like children to them. Basically, pigs have been popular storybook characters for generations, basically from AA Piglet to EB, White Wilbur, or White's Wilbur. Pigs have an endearing and flavorful quality about them. Sorry, Brandy, we know pigs are friends. There's basically hundreds of different breeds, which most of them descend from the wild boar. So they also produce bacon, ham, baby back ribs, spare ribs, sirloin. I have a feeling Brandy's gonna get me on this one. Pork belly, and also more delectable barbecue items. But basically, you can definitely observe this day by cuddling with one or reading about one. You can use a hashtag National Pig Day to post on social media your favorite little pets. You can comment on our Facebook page if you have a pig that you'd like to share with us.
Sounds like fun.
Yes. Today is also National Read Across America Day by Dr. Seuss. So pick up a book and enjoy some reading time. Maybe some green eggs and ham since it's National Pig Day.
That would be a good choice.
And lastly, it is National Employee Appreciation Day. So basically, remember to be kind and appreciate your coworkers. So I appreciate you.
I appreciate you.
Okay, so we're just going to go ahead and kind of jump into today's topic. Of course, we did go ahead and kind of do an introduction. So you are our personal injury paralegal.
That's correct.
So a lot of people don't, there's different varieties of personal injury.
Mm-hmm.
So, but basically today we're going to discuss slip and falls. So,
Right.
So Brian, basically what is slip and falls? Are they really a legal issue?
They absolutely are a legal issue. It falls under a complicated and difficult area of law that's known as premises liability. So premises liability is the idea that if you are a guest on somebody else's property and you are injured because of a dangerous situation that the property owner or manager caused or let happen, they are liable or legally and financially responsible for your injuries. It can include slip and fall, as it says. It can also include tripping or falling in any kind of capacity, really any injury that is caused by a dangerous situation on somebody else's property falls under the general umbrella of what we call premises liability. It definitely is a legal issue, but it's a tricky one to navigate. There are a lot of hurdles that need to be met in order to have a viable premises liability case. In order to have a viable premises liability, you have to be what's known as an invitee. Now, that doesn't have to come with an engraved invitation, right? Any instance where the owner or the manager of the premises knows that you're there and they want you to be there counts as an invitee. So if you are in a business that's open to the public, you're an invitee. You're there to do business, to buy something. Maybe you're staying at a hotel. Maybe you're at somebody's office for an interview, or you're just in the store shopping. That counts as an invitee. And of course, it counts if if you're invited over to somebody's home. That counts as an invitee. Even if that you are, say, delivering something. That person, if you have asked someone to come to your place, to your residence, that counts as an invitee. The second sort of hurdle that you have to meet is that there had to have been a dangerous situation on the premises, right? It had to have been what we call an unreasonable risk. There are lots of instances where going to a premises might come with a certain amount of assumed risk, right? If you go to a pool, there's a certain amount of assumed risk that if you don't know how to swim, you could drown, right? So it has to be something that is above and beyond what should be reasonable for that location. And they have to, the owner and the manager of the premises have to have either knowledge that that dangerous situation did exist, or it has to be something that they should have known. You have to be able to prove, that's probably the highest hurdle to jump, is that you have to be able to prove that the owner or the manager of whatever premises it is that you're on, if it's a store, an apartment complex, somebody's private home, that they knew that there was a danger, or if they didn't, that they had a responsibility to know and they ignored it. Or so, for instance, if you're at a grocery store, right, they have a responsibility to make sure that if that there aren't spills on the floor. If there's a spill that's been there for ages and ages and no one's come by to clean it up, that could potentially meet that standard of the fact that that premises owner should have known that there was an unreasonable risk in their location. And then that gets into that they have to have the opportunity to either warn the person, the invitee, that there was a reasonable risk, or even better yet, have done something about it. So if there is a dangerous situation on somebody else's property that they knew or should have known about and they didn't do anything about it, you could very well have a viable premises liability, or it's often called a slip and fall case.
Okay. So kind of examples, say you're at a restaurant. And the employers basically have their employee handbooks, guidebooks as far as like cleaning and different things. Say that I was just kind of walking along and fell on a shrimp.
Okay. Sure.
Would that constitute as far as a slip and fall?
Yeah, well, so it's important to know, as paralegal, I do not have a JD. So I'm not an attorney. And it would depend, right? Every case is going to be dependent on the actual facts of the situation. A hypothetical situation where there's some shrimp, some food on the floor, you're getting up to go to the bathroom, you step on it, you slip and fall. So one of the things that you would need to be able to prove is that the restaurant knew that that shrimp was there, or that they should have known. So let's say in this situation that you're walking right behind a waiter, and the shrimp falls, and then you immediately step on it once it's hit the ground, and you slip and fall. That may not meet that standard because there was no opportunity for the premises owner to know that that dangerous situation was there and then to do something about it.
Okay.
Possibly. Now, if there was a spill, somebody's carrying a tray of food, it falls over, and then they don't do anything about it. They don't have someone stand next to it to warn, guests. They don't put one of those, everyone's seen those little yellow or orange warning cones. They don't have anyone come and pick it up, and it's been sitting around for a while. That could very well be, a viable premises liability case.
Okay. So when it comes to basically how are we able to help someone that has a slip and fall?
Well, we are a law firm. We are attorneys, not
Yes.
you and I, but we
We're the
generally
paralegals.
the Brandy Austin Law Firm. We have attorneys here, so obviously the first and best way that we're able to help is we're able to offer legal representation to successfully ferry and guide you along your potential premises liability or slip and fall case. In these kind of situations, inevitably, the owner or the manager of the premises is going to do whatever they can to distance themselves from their liability, right? This is a business, or it could be someone's home, it could be an apartment complex, it could be any kind of place, it could be a public park, and it could be the city that is the premises possessor, what we call that. So they're going to do what they can to say that it wasn't their fault, or even better for them that it was your fault, and to say, well, we shouldn't have to pay for any of your medical bills. So having a lawyer, an attorney, is an important part to strengthen your defense, right? So that's what we can offer to make sure we have attorneys here who have decades of experience practicing personal injury law. They know premises liability. They can use their knowledge and expertise to enforce the law in these kind of situations and say, no, this is what the law says, and then we can investigate the facts, and then we can put together a credible, airtight defense for your premises liability. The second kind of biggest thing that we can offer is what are called letters of protection.
Yes.
So when you're involved in any kind of personal injury case, whether it's a motor vehicle accident or a slip and fall or anything else, one of the biggest difficulties that our clients face is how are they going to pay for the treatment? Especially because we all know lawsuits, they take a long time. It's not something.
They don't happen tomorrow.
Right. You don't slip and fall and then get a check in the mail the next day. So what are you supposed to do if you're in an accident, you're injured, you need medical attention, and you have difficulty paying for it? That's where we as a law firm come in. We can offer what are called letters of protection. Quick and simple. It's an agreement that we make with medical providers to allow you to treat upfront without having to pay anything, because we have agreed to make sure that they will get paid out of whatever settlement is reached or damages may be awarded at trial. So you can treat. They withhold billing until we have closed out your case, at which point, if there's a settlement, we can pay them out of that settlement. So it allows you to treat and not have to pay up front, which is an advantage that you can get from having an attorney.
Because a lot of people, that's one of the things is that they have insurance, but then of course, subrogation and different things kind of get into that element. So not a lot of firms offer, protections, but it always does. I've always said it's always better to have your attorney in your back pocket, because there's things that you aren't aware of. Same with your own insurance company.
Right. I mean, some, you might not be able to find a doctor that can treat you even if you have insurance.
Exactly.
If your insurance pays, they may, say that you owe them money back.
Yeah.
There are all kinds of difficulties and unforeseeable circumstances that can come up when you have these kind of accidents. So like you say, having an attorney is always beneficial. With personal injury, we bill out of a contingency fee. So that's the other great thing, is that you also don't pay for our services up front either, right? You are paying us out of whatever settlement comes, so you can get representation, you can get medical treatment, and not have to pay anything until it's all said and done.
Correct. So, and can you kind of, and we touched bases a little bit about the process. I know as the senior paralegal for the firm, I don't handle so much the personal injury side, but I do get the calls from the clients as to, oh, my process is taking so long, they promised this, it's been 2 weeks, why don't I have a check? So basically, can you touch bases on the process of?
Yeah, that's one of the trickier parts of the this whole process is it's impossible to know how long any particular case is going to take at the beginning. There are all kinds of variables that go into how long a case takes from your very first meeting with the attorney to going to pick up your check and close out your file. One of the first and one of the biggest determining factors in how long a case can take is the length of your treatment. There's not a lot that really happens while you are still treating. Your settlement is going to be, settlement negotiations are going to be based primarily on the amount of your medical bills. So if you're in an accident, we're negotiating a case for you, our damages are, 90% of them in a lot of cases are going to be based on what your medical bills were. We can't know what your medical bills are until you actually have them, right?
Yes.
We want to make sure that if you're treating, that the full cost of your treatment is covered, not halfway. So there's not a lot that really goes on while clients are still treating. If it's really short treatment, great, boom, we can move on to the next step. But there are lots of, people that they have extended treatment. They may have procedures that are going to cost tens, even hundreds of thousands of dollars. So the length of that treatment is probably the single biggest determining factor in how long a case takes from beginning to end. The second is just that every case is different, every client is different, every insurer is different, every provider is different, and there's no guarantee how responsive all of those people are going to be. Some medical providers are really great at answering our requests for documents and bills right away. Others, especially if you're not treating through a letter protection provider, they may ignore our requests, or they may get lost in the shuffle. If you're having to deal with Medicare and Medicaid, there is a bureaucracy that goes into requesting documents. So, the responsiveness of medical providers to our requests, the responsiveness of insurance adjusters in the negotiation process, and even sometimes in the responsiveness of clients. It's always important that if you have a legal case, to take an active role. It is, after all, it is your case. We're here to guide, to advise, to facilitate, and often to do things on your behalf, the things that we have expertise in. But there are instances, cases where we may need something from a client. And it's if the client is unable or unwilling to respond, well, that adds time, because we can't do anything without the client's authorization, right? We can't settle a case unless the client agrees to a settlement. And then probably the second biggest thing when it comes to how long the case takes is if we go into litigation.
That's kind of pre-lit, and pre-lit, and we'll kind of touch more basis on it, but kind of pre-lit after treatment, basically it's the demand where we start negotiations.
Right.
That's pre-lit. It's before litigation is actually filed in the court system. And then of course if we get to filing, then we have the court proceedings. So then you have discovery, and then you depositions, and mediation. But average, we try to span 2 years. I always try to say realistic expectations. 2 to 3.
There's no way. That clock really starts over once you file suit, because then at that point we're operating on the court system, and everyone knows courts are backlogged. Judges, benches sit empty, for various reasons, for all kinds of cases. Their docket goes way, way, way back. So if we filed a case today, we may be looking at an initial trial date not this year, but even the next year in 2021.
That's correct.
So the litigation process, it kind of is what it is sometimes. But yeah, I think, 2 to 3 years, if that includes litigation, is a reasonable expectation for what you could potentially be looking at. Which again, is a benefit for having an attorney.
Exactly.
If you had to imagine having to wait, that amount of time and then treat, right? Having that letter of protection, being able to at least take care of your health, take care of your well-being first, and then have us manage the rest of it along the rest of the way.
And just some quick tips kind of regarding, if you slip and fall, I always say as far as pictures, documentation, your medical records, I'm a firm believer in, I still have different notebooks for different things, because of course when we're talking about a 2 to 3 year scope, you forget things
Yeah.
that are important. So I always say kind of keep a notebook as to any information, what doctors you've treated at, your mileage, your prescriptions, there's so much stuff that you are easily to forget.
Right.
And you can always have that to kind of go back. But definitely we always say kind of when in doubt, our firm specifically does offer free consultation. So if you ever, fall or have any type of personal injury, definitely contact an attorney. And then that way we can investigate, see if you have a claim, and then we can kind of assist as far as from there. So
Yeah, you've covered a lot of you're the senior paralegal, you know your stuff. You covered a lot of the parts of what you should do if you have a slip and fall. If you've slipped on ice, you've slipped on water, maybe you've tripped on, a cracked piece of sidewalk, or, maybe a staircase is broken and you stumble and fall. Obviously, the first thing that you need to do is make sure that your health is taken care of. If you're injured, call a paramedic. If you're at a business location, call for help. Your health always has to be your number one priority. And the second thing to do is to make sure that you notify the owner or manager of the premises that an accident has happened. That's an important step. If you're in a business, say you're at some sort of store, make sure that you talk to a manager. If you're in an apartment complex, make sure that you talk to the management there. If you're at somebody's house, make sure that the homeowner knows that something has happened. But it's important to be careful what you say. Make sure that you get, if it's at all possible, get something in writing, some sort of incident report, saying that, this happened, I spoke to this person. Keep to the facts though. Document, take pictures if you can. The shoes, the clothes that you're wearing, keep those. Make sure that you take the time to write down everything that happened in the greatest detail that possible that you can. And then come to us, come to an attorney, talk to a lawyer to find out if you have a case and how they can help.
Okay. Which I know that was a lot of information and stuff, but we definitely, especially personal injury, we'll definitely be touching bases again with some of the stuff that we do. But basically, that's all the time that we have for today. So we're glad that you joined us on Disclosure Live with Brandy Austin Law. Please enjoy your weekend. Don't forget to subscribe to our YouTube channel. Leave us any comments, ask any questions. We'll be back and see you within 2 weeks. And I'm Heather Jamison, and this is
Bryant. It's nice to be here. This is my first time on Facebook Live.
So happy Friday, and thank you for watching, guys.
Bye-bye.